Hi, my name is Stephen Choi. I want to talk to you about your upcoming arbitration. An arbitration can best be described as a mini informal trial, but instead of a judge and jury, a neutral arbitrator will decide your case and render an arbitration award. The arbitrator will decide whose fault the accident was and how much money the defendant should pay you for causing your injuries. Most arbitrations are what they call non-binding. This means that either side can reject the arbitration award. For example, if you think the arbitration award is too small, you can reject the award and proceed to trial. If the defendant thinks the arbitration award is too big, he or she can reject the arbitration award and proceed to trial. In some cases, the arbitration is binding. This means that whatever the arbitration award is, both sides have to live with it. But don't worry, before an arbitration can be binding, you must agree to this in writing. We'll talk more about binding arbitrations later on. So how is the arbitrator selected? In most cases, the parties' attorneys will mutually agree on an arbitrator they both think is fair. In some cases, the court will randomly select the arbitrator. In either case, the arbitrator will almost always be an attorney or retired judge who is very familiar with your kind of case. Your participation at the arbitration is mandatory. If you fail to complete your arbitration, the court can throw out your case. If you miss your arbitration and cause it to be rescheduled without giving anyone notice, the court can sanction you $1,000 more or less. If the date and time scheduled for your arbitration is not convenient for you, you must notify us immediately. In most cases, we'll need at least a week notice to change your arbitration because it involves so many different people. So let us know right away if the date and time of your arbitration is not convenient. Let's talk about what will happen at your arbitration. Let's start with who will be there. You will be there, your attorney will be there, the defendant will be there, the defendant's attorney will be there, any witness the parties have will be there, the arbitrator will be there, but there will be no court reporter. We'll talk about this more later. Your arbitration will be held at the arbitrator's office. It'll be an informal setting. It'll last anywhere from 2 to 8 hours, sometimes multiple days, but this all depends on how complicated your case is. As I stated earlier, there will be no court reporter because your arbitration is confidential. So anything you say or do at your arbitration cannot be used at the time of trial. This goes also for the defendant. Anything the defendant says or does at the arbitration cannot be used at the time of trial. In fact, anything that happens at the arbitration, any evidence that is used, any witness that testifies, this cannot be used at trial. The arbitration award can't be used at trial. For example, let's say the arbitrator gives you $10 million and the defendant rejects this award. You can't go to trial with the arbitration award and say, well, the arbitrator gave me $10 million. No, that is inadmissible. Nothing that happens or is produced by the arbitration can be used at trial. And you might ask why. And the reason is that arbitration is supposed to be a tool to get a case settled. It's not supposed to be a time for the parties to gather evidence. And so the rule is that no evidence presented at the arbitration and nothing you say or nothing anyone says can be used at the time of trial. Before the arbitration, the parties will submit an arbitration brief to the arbitrator. The brief will contain the parties' version of the case and all the evidence that the parties plan to submit at the time of arbitration. For example, we'll include in the arbitration brief all of the photographs, your medical records and bills, the police report if there is one, any witness statement that is relevant, and any and all evidence that we plan on introducing at the time of the arbitration. What this means is that before your arbitration even begins, the arbitrator will already be familiar with your case. The arbitration will usually start with your testimony. This means that you give the arbitrator your version of how the accident happened and you tell the arbitrator about your injuries. Your testimony is presented in a question and answer format, which means that your attorney will be asking you questions and you'll be answering the questions. For example, the attorney will ask you, when did your accident happen? Where did your accident happen? What injuries did you have? What doctor did you go to? Questions such as those. So all you have to do is just answer the questions. After you're done with your testimony, if we have any witnesses, our witnesses will then testify. after all of our witnesses are done testifying, then it's the defendant's turn, and they put on their case, and the defendant will testify, and then the defendant's witnesses will testify. When they're done with their testimony, then each attorney will give a closing argument. In the closing argument, each attorney summarizes their case to the arbitrator, and after that, the arbitration is over. Then the arbitrator will think about the case and write up an arbitration award. It can take anywhere from 1 day to 1 month, depending on how busy the arbitrator is. Once we get that arbitration award, we will post it on the client portal so you can take a look at it. Your arbitration award will also be filed with the court. Now, once this arbitration award is filed, each side has 60 days to reject this arbitration award. If you don't reject the arbitration award within 60 days, then the arbitration award is final. So we will post the arbitration award for you to look at it. We will also tell you how much money you'll get from the arbitration award after you pay off all the doctors and the attorney's fees and costs. And then you tell us, do you want to accept the award? Do you want to reject it? I want to talk to you now about penalties that attach if you do reject the arbitration award. The arbitration process is designed to settle cases so that the court doesn't have to expend resources in having a trial. So the court will impose penalties on any party that rejects an arbitration award but doesn't do better at the time of trial. So for example, if we get awarded $100,000 and we go to trial and we only get $90,000, the court is going to penalize us for not accepting the $100,000 award. Conversely, if the defendant rejects an arbitration award of $100,000 and then we go to trial and then we get an award of $110,000, then the court will penalize the defendant for rejecting the arbitration award. And the penalties can be pretty severe. We're going to have to pay all of the defendant's costs, expert witness fees, the cost of the arbitrator. We might even have to reimburse the court for the cost of the arbitrator. So, once your arbitration award is rendered, we will meet with you and talk with you about whether or not you should accept or reject the arbitration award. Let's talk about how you should prepare for your arbitration. You should prepare for your arbitration the same way you prepared for your deposition. Start by watching this video and pay attention very carefully. Then schedule an appointment with our office. We want to meet with you in person and go over your testimony. We want to make sure that you know what questions we're going to ask you at your arbitration so that you are prepared to give the best answers possible. We want you to take a look at your deposition transcript and read it hopefully at least once, preferably twice. It's very important that the testimony that you gave at your deposition is the same testimony that you give at your arbitration. Your deposition will be posted in the document section on the client portal. You might also want to visit the scene of the accident again to make sure you're familiar with the scene of the accident and go over the police report, the medical records, any witness statements, all of the evidence in your case. We will also post the arbitration brief that we talked about earlier. This will also be in the documents section. Make sure you read the arbitration brief carefully so you know what our version of the case is and you know what the evidence is going to be. You also want to let us know if you think there are any witnesses that might help our case. So if you have any friends or family that you think would be good to testify at the arbitration, who could talk about your injuries and how much pain you were in, that would be very helpful. So all of these things, if you do all of these things to prepare for your arbitration, it will be a success. Let's talk about how you should conduct yourself at your arbitration. You should conduct yourself at the arbitration pretty much the same way you conducted yourself at the deposition. First, you want to dress very nicely. You want to make it very clear that you're taking this arbitration very seriously and this is very important to you and that this is a big case. And you want to make a good impression on the arbitrator. So dress very nicely. We'll talk about this in our meeting. Once you're at the arbitration, you want to make sure that you're very respectful, very polite, very courteous. You don't want to be rude or angry or exhibit any type of behavior that will put you in a bad light. When you are being asked questions by the defendant, you don't want to get upset. You want to be patient. And you want to, again, be very respectful of everyone there, including the defense attorney. Now, when you are asked questions about your injury, and we went over this in the video and in our meeting about your deposition, this is an important time and your opportunity to express and articulate to the arbitrator just how badly you were injured. And so you don't want to underestimate or minimize your injuries. Of course, you don't want to exaggerate your injuries either, but you want to make it very clear just how bad this accident was for you. And we know from talking to you and meeting to you that this was a serious accident and you suffered injuries and this really affected you. And we just want to make sure that you're able to convey that to the arbitrator. It's okay to show emotion, it's okay to show pain, and even you can show some anger at the fact that this accident happened, as long as it's somewhat controlled. So I know this is a little bit contrary to what we told you earlier, but when you start talking about your injuries and the pain and suffering, it's okay to be emotional. Again, we will practice this more in depth when you're in our actual meeting, but be prepared to articulate and convey your injury and how much it affected you and how bad this was for you. Now, if you have any questions about the arbitration process, just let us know. You can give us a call, you can post an update on the client portal, and when you come in for your meeting, we can talk about it then. Your arbitration is very important, and we want it to be a success. Thank you very much.